Hey, what's going on? It's Instructor Mike. You can follow me on Facebook at Mike Brown or Instructor Mike. Follow me on Instagram at Yes Mike Said It, and subscribe to my YouTube page, Instructor Mike. Hit the subscribe button, hit the bell for notifications. I'm doing laundry right now. That's what I should be doing. But right now, I'm going to go on ahead and introduce my new segment to you. Instructor Mike, what are my rights? And this segment is going to focus on the Fifth Amendment to the United States Constitution and what you should do after a use of force situation. I want you to understand that the Fifth Amendment to the United States, first of all, the first 10 amendments to the United States Constitution or in the United States Constitution are known as the Bill of Rights. And the Fifth Amendment is no exemption. It's no exemption from that. It's obviously included in the first 10. And I want you to understand that the Fifth Amendment specifically states no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia or when in actual service in a time of war or public danger, nor shall any person be subject for the same offense twice or to be twice put in jeopardy of life or limb, nor shall, and this is where it specifically applies to you specifically as relates to what we're about to talk about, nor shall any person be compelled to be in a criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So let's specifically talk about the part where it says nor shall be compelled in any criminal case, not civil, but criminal case, to be a witness against himself. So let's introduce Miranda versus Arizona, 384 U.S. 436, 1966. That is the landmark Supreme Court case which specifically mandated or required that law enforcement officers or agents of the government specifically advise suspects of their rights to remain silent pursuant to the Fifth, that anything that they say can and will be used against you in a court of law pursuant to the Fifth, that you have the right to an attorney, and if you cannot afford one, the government shall provide you an attorney, obviously because they are the one that is seizing your body for the purposes of presenting you to answer for a violation of the laws that they put in place, okay? And that you could stop answering questions at any time and request a lawyer, and that you knowingly and voluntarily waive those rights. Now, therein is a bit of a tricky situation. If I have the right to remain silent, shouldn't I just remain silent? I don't have to speak to you, right? You could ask me any kind of questions you want. I don't have to say anything to you. Why? Because the Fifth tells me I have a right to remain silent, right? Wrong. You absolutely can try to remain silent. You may have some problems. Let's look at Burgess versus Thompkins, 560 U.S. 370, 2010. And that is a case where a murder had taken place. The police were interrogating a person, obviously, in the interrogation room, and they were asking questions. This person was remaining silent, doing all kind of nonchalant things to, kind of distract attention. And at approximately 2 hours and 45 minutes, a question was asked of that person along the lines of, do you pray that you enter into heaven for what you did to that boy? Something along those lines, where the question directly was implicating him in that crime, and he stated yes. Well, that statement was used against him, and on a motion to suppress, in essence, certain cases in that specific case, it was stated that the invocation must be clear. It can't be ambiguous. The Supreme Court held that silence during interrogation is not an invocation of a right to remain silent under Miranda. That the invocation of your desire to express that right and to use that right must be clear. Silence is not enough. Once Miranda warnings are given and you start talking, That talking right there is considered a waiver of your Miranda rights. So how do you protect yourself as the individual citizen who may have never heard of a case law or a case like this, such as Burgess versus Thompkins? The best thing for you to do is that as soon as you get into contact with the police, whether you believe you are innocent or whether you know you're guilty, whatever the case may be, the best thing for you to do is automatically state, especially if you truly are the victim of a crime, officer, I am the victim of a crime and I would like to invoke my rights to remain silent and request a lawyer. I will give you a statement later in the presence of my lawyer. Okay, I'll repeat it again. Officer, I was the victim of a crime and I was forced to defend myself. I will give you a statement later in the presence of my lawyer. I'd like my lawyer and medical attention, please. Okay, that will help you. Now, for those people who want to state that, well, I can just go on ahead and remain silent and not request a lawyer, I introduce to you Salinas versus Texas, which is another United States Supreme Court case, 570 U.S. 178, 2013. That's the case citation. That's where the Supreme Court, and again, a 5-4 decision, they stated that you must invoke your decision or your exercising again of your rights to remain silent and to request a lawyer. And all this was an extension of the Burgess versus Thompkins decision in 2010. That decision was about whether or not a suspect who understands their rights, is aware of their rights, but does not invoke it. And then the Salinas versus Texas specifically indicated that you must invoke that right, that your silence is not enough to state that you want to exercise those rights. You must invoke that right. Now, naysayers or people who don't believe in the court's decision would argue that, well, the Fifth Amendment just states that, I have the right to remain silent. So what is understood doesn't have to be repeated, doesn't have to be said. Why is this even a debate? Well, it is a debate. Imagine that you're going through the drive-through, and in particular, let's just say McDonald's or White Castle or whatever your favorite fast food restaurant is, just because they have things to eat and they can provide you those things to eat, it is not implied because you pulled up to the drive-through and, they asked you welcome, or stated welcome to McDonald's or White Castle's, whatever, I'm here. Or you state I'm here, and all of a sudden not only do they know that A, you want to eat, but B, what you want specifically to eat. You have to invoke not just that you're hungry. I wouldn't state that I'm hungry, it would be implied because of your presence there, but you need to let them know specifically what you want so they can serve you what you want. Doesn't mean that service is going to be good, doesn't mean it's going to be bad, but they can't serve you for you to find out whether or not that service was good or bad unless you specifically state, I want the number one, the number two with extra this, extra that, hold this, light ice, this, that. You have to specifically state it. So look at the United States Constitution like a menu, right? And specifically as it relates to the Fifth Amendment, you must express that, one, I'm the victim of a crime and I was forced to defend myself. I'd love to give you a statement later in the presence of my lawyer. I'd like my lawyer and medical attention. That way, that it is expressed. You put the government on notice that you want to exercise those rights and that they must stop talking to you, especially as it relates to that case. Now, that doesn't mean they're going to stop. They can still try, but at least you put them on notice, okay? Now, let's talk about another case, North Carolina versus Butler. This is 441 U.S. 369. It's a 1979 case, and this is about whether or not the statement of a suspect in interrogation, if the police must show that a suspect explicitly waived their Fifth Amendment rights to incriminate themselves. So let's talk about the facts of the case so that you can get a better understanding of this case. The FBI read to a suspect their Miranda versus Arizona on a typical advice of rights form, that you have the right to remain silent. Anything you say can and will be used against you in the court of law, that you have the right to an attorney, you don't have to, and that if you can't afford one will be provided for you, that you can stop talking at any time and refuse to answer questions and ask for a lawyer. And so what happened is, in this situation, the suspect didn't sign the paper, right, the advice of rights form, but started talking to the FBI. And so he made incriminating statements about what he was alleged to have done, and those statements were used in court. During the proceedings, there was a motion to suppress on the grounds that, well, the waiver of those Fifth Amendment rights was not expressly made, okay? And so the Supreme Court rejected that petition, or that suppression, in essence, as it, got to the Supreme Court, stating that, well, anytime you start talking to the police, especially if you knew of your rights, which you don't indicate that you didn't know, you state that you knew, but just that you didn't sign the form, and that, well, there was no express waiver of it, so I didn't waive my rights and they should have stopped talking to me. No, the minute you started talking to them, you waived your rights, okay? You waived your rights. And so what we're starting to see, if you examine the United States Supreme Court case or cases that affect the Fifth Amendment, is that there is always a balancing test of the government's interest in stopping crimes from happening and protecting American citizens versus the individual liberties and the rights that citizens have pursuant to the Constitution. You typically cannot add to or take away from those rights, and so you typically see a balancing test always being applied. Whether it's fair or unfair, I leave that to you to opine about. But the best thing to do to protect yourself is to automatically invoke that you would like to remain silent and that you want a lawyer. You don't know what kind of evidence the government has against you, and given that this is a criminal case, we're not talking civil, that's a different standard, but given that this is a criminal case, the best recipe is not physical silence. Treat the Constitution like a menu, and if you want to invoke those rights to remain silent and to request a lawyer to stop the talking, or at least to put them on notice that they should stop talking, officer, I was the victim of a crime. I was forced to defend myself. I will give you a statement later in the presence of my lawyer. I would like my lawyer and medical attention, please. Put the government on notice. Remember that statement. That statement will be the greatest thing that will help you, even if you feel you are innocent. You don't know if the government or if the police share your beliefs. Okay? And so you have to protect your rights. Any defense attorney worth their salt will tell you that. And we're going to end with this. If you do some wordplay, what's the opposite of anything? Nothing. What's the opposite of for? Against, okay? Or what's the opposite of against? For, right? So if anything you say can and will be used against you in the court of law, it's the same thing as saying nothing that you say can and will be used for you in the court of law. So you have no benefit in providing that statement, only in essence to appeal to your ego or your sense of, do they believe me? Don't they believe me? And so that's why you might be, compelled in essence within yourself, not from the government, but within yourself, your own psyche, right, to speak. If you are innocent or guilty, whatever the case may be, that's you, that's your case. The best thing that you can do is not remain silent. Invoke your Fifth Amendment rights. Officer, I was the victim of a crime. I was forced to defend myself. I would like to make a statement later in the presence of my lawyer. I'd like my lawyer and medical attention, please. Put some little sauce on the top of it, please. Okay? All right, this is Instructor Mike, and you've been trained. Follow me on Facebook at Mike Brown or Instructor Mike. Subscribe to my YouTube page, Instructor Mike. Hit the subscribe button, hit the bell for notifications, and follow me on Instagram at Yes Mike Said It. Look, get your butt in someone's concealed carry class if you're able to. It's no one's job to protect you but you. Stay tuned for the next episode of Instructor Mike. What are my rights? I'll see you.